Hello and welcome to Hindi newspaper analysis, 8th November 2022. In today's newspaper, there was an article which was predominantly covered in all sections of the newspaper, and even editorial completely discussed about only this judgment, that is judgment regarding economic weaker sections. If you see here, almost 3 pages covered and editorial completely described only about this judgment only. Before understanding this judgment very clearly, let us try to understand some basic concepts with respect to reservations. A very famous one is Rawls theory in 1971, which suggested difference principle. The main core of the concept is this Rawls theory suggested that inequalities can be permitted. Inequalities can be permitted to benefit the weaker sections, that is to benefit the least advantaged group. To benefit the least advantaged group, we can suggest these principles. We can use the positive discrimination to benefit the least advantaged sections. Further, we have affirmative actions, which is the core of Indian Constitution. Our constitutional forefathers put forward affirmative actions which denotes that a positive discrimination to correct the historical injustices. Now here, these two concepts are very handy for us to understand these concepts, this judgment particularly. So one is difference principle, which is providing inequalities, providing some provisions for the least disadvantaged section, and affirmative actions for the people who are facing historical injustices. So to correct this historical discrimination, we have affirmative actions. Further, the next important concept which is helpful to understand this judgment is doctrine of basic structure, evolved in the famous Kesavananda Bharati case, and in which in 1973 Supreme Court put forward that the core of the Indian Constitution, core values of Indian Constitution is not subject for change. You could not abrogate even by the constitutional amendment. Then we need to understand this judgment also, Indira Swani case, in which Supreme Court of India fixed a ceiling limit of 50% on providing reservations to the BCs. At the same time, it also put forward the condition of educational backwardness is the criteria, not economic backwardness. So after understanding these 4 concepts, let us try to understand the judgment clear. For those who are not aware about the whole concept, I am going to explain you that on January 12th, Government of India put forward Constitutional Amendment 103 and provided 10% of reservations to the economically weaker sections of open category people in the year 2019. So it was brought by amending Article 15, Article 16, and later it added Article 15 Clause 6 and 16 Clause 6 to the Indian Constitution. Immediately after the passing of bill, we found bunch of petitions started to created in several courts. Now Supreme Court of India investigating this, getting the procedure of this case, and it started to take up the cases, hearing the cases from last few years. But what happened is very interestingly, yesterday Supreme Court of India passed its judgment with 3:2, and you can see that his judgment was passed with a 3:2 split, and let us try to understand the judgment in a detailed manner. So from the majority view, that is the people who supported this, clearly stated that it is not the violation of basic structure. It is not the violation of basic structure, and in fact it also suggested that particularly judges like Bhela Trivedi clearly suggested that they are part of affirmative action. Affirmative actions, that is which will benefit the economic weaker sections. And this 103 amendment, according to Justice Bhela Trivedi clearly stated that it will also provide a separate class structure for these people and help them in upgrading, in progressing in their life. And further, it also mentioned that our constitution provided that treating unequals equally is a violation of equality under constitution. So she particularly mentioned these words, that is, unequals cannot be treated equal. Treating unequals equally violates equality under the constitution. That is, you cannot group the unequal people as the same group. So now within the within the general category students, you found some weaker sections, and these weaker sections should be treated separately. That is the view of Justice Bhela Trivedi. Further, we have to understand that this allocation of reservations according to Justice UU Lalit also permissible by DPSPs. Here the dissenting judges also, that is the judges who opposed it, for example we have Justice Ravindra Bhatt and UU Lalit, both mentioned that yes, it is permissible. It is acceptable to provide economically weaker section reservations because DPSPs stipulated to fulfill the objectives by providing special provisions on economic criteria. So DPSPs gave a chance to provide special provisions on economic criteria. As you know very well that it's an obligation under the state as per Article 37, moral obligation under the state. They can go ahead. They are not opposing it. But the thing is, after listening the arguments, they even said it is violation of basic structure on one principle. I will get to that principle within few minutes, but let me explain you this very clearly. Majority view of the judgment said that it is not violative of basic structure. In fact, it is providing benefits to the economical weaker sections, those who are unequal among the equals. Then it is also helping them to become economically empowered, they are socially empowered, and they can get the benefits of reservation. Further, they also mentioned that it is permissible by DPSPs because DPSP stipulates to fulfill objectives of the state provided on the special provisions on the economic criteria. That is, on the economic criteria, they can provide some assistance to the people to realize the DPSP's goals. On that pattern, on that aspect, it was permissible. Further, but the dissenting judges, because there are two judges who dissented this argument, so here they put forward interesting point of discussion, very interesting point of discussion, because they brought particularly UU Lalit and Justice Ravindra Bhatt. They mentioned that the constitutionality, or you can say it is very much valid to provide, we are permitting it, but the thing is it is violating basic structure because it is exclusionary, it is following exclusion principle. To understand exclusion principle, let us try to examine this exclusion principles in three aspects. Okay, because Justice Ravindra Bhatt, who raised his voice against this constitutional amendment, particularly this exclusionary principle, he brought this idea very clearly. First one, its exclusion principle is very arbitrary because it is not helping the weaker sections in the other category, because it believes that the reservations for the other category people, the 103rd amendment believes that reservations to the other category people, maybe they are satisfied and they are okay, they are progressing. That's the reason they are excluded from this economic weaker sections, because the people whoever allocated, they are confined, whoever allocated previous reservations, they are confined to the old reservation, which is based on socio-educational backwardness. Even Indra Swani case also said this, only educational backwardness. Now this exclusionary principle, because it is denying, it is not accepting people to take benefits of reservations on this economic weaker sections. That is, it is denying chance to the mobility of the people. Chance to the mobility of the people from caste-based reservations to economic-based reservations. This is exclusionary principle. Ante Article 16, Clause 4, Clause 5, 15.4, 16.5 ఏమైతే రిజర్వేషన్స్ ప్రొవైడ్ చేశాయో సోషల్ ఎడ్యుకేషన్ బ్యాక్వర్డ్నెస్ కింద ఆ రిజర్వేషన్స్ మాత్రమే వాళ్ళు కన్ఫైన్ అయిపోయారు. వాళ్ళకి వేరే రిజర్వేషన్స్ తీసుకునే, వేరే ఇన్ ద సెన్స్ ఎకనామిక్ బ్యాక్వర్డ్నెస్ ప్రిన్సిపల్ పైన రిజర్వేషన్ తీసుకునే అవకాశం ఈ 103 అమెండ్మెంట్ దట్ ఈస్ 16 Clause 6, 15 Clause 6 ప్రొవైడ్ చేయడం లేదు. మోస్ట్ ఇంపార్టెంట్ డిసెంట్ ఆర్గ్యుమెంట్ వీ హ్యావ్ టు అండర్స్టాండ్ హియర్. Right? So the exclusion principle maintains that it is arbitrary, it is not correct. At the same, it is confined to the old reservations because people whoever followed the reservations, they are confined to the old socio-educational backwardness. They are not getting opportunity to enter into this new reservations, particularly economic based reservations. So that is exclusionary principle, very, very important to understand. Further, next, it is also explains that it is providing the Orwellian concept. Justice Ravindra Bhatt used this word in his judgment. Orwellian concept means it's an idea that being destructive to the welfare of the open society, that being idea that is being destructive to the welfare of the society. Try to understand. He believes that welfare of open society, it is not at all benefits to the open society. You are separating the people and you are limiting the people within the prescribed structure. That is, only economic sections, only economical weaker sections, that too in the general category is available to use this economic weaker section category. As others are already getting the benefits, it is not at all good for the society. It is a destructive for the open and the welfare society. That's the reason it is called as Orwellian structure and Orwellian idea. Next thing is, here Ravindra Bhatt quoted, and I quote, Sinha Committee. Sinha Committee was published in the year 2005, and this Sinha Committee spoke about the reservation, the backward people in India. Okay, that is, Sinha Committee stated that within the SC people, and I quote, within the SC people, there are 38% who are in the below poverty line. Within the ST people, there are 48% in the below poverty line. Within the OBC people, they are in the almost 33% are in the below poverty line. And within the general category, there are 5.5 crores people, and it is amounts 18.2% of the people who are at the below poverty line. So if you compare this data according to Justice Ravindra Bhatt, again he said that this data of Sinha Committee highlighting that bulk of the poor people, bulk of the people who are living below poverty are within the reservations of Class 15.4 and 16.4. That is, SCs, STs and open and backward classes. So Sinha Committee highlighted that these people, the economically weaker sections, even found in the SCs and STs, but they are only limited to get the social educational backward reservations. Why they are discriminated, why they are excluded, why they are forgotten by this economic weaker sections, that is the point. Further, here Justice U. Lalit and even Ravindra Bhatt cautioned the government because it is crossing the 50% limit. You know very well that we have 76th Amendment of Indian Constitution, which even provided to Article 257A, which is also pending in the Supreme Court, which is on the principle of violation of 50% leaning, 50% ceiling. Okay, so 76th Amendment 1994, it is one of the contentious amendments, still it is pending in the court. we will wait and watch for the next update on this particular amendment, particular section 257A. Okay, so particular article 257A, we will try to understand. So if you see this overall judgment, majority judgment say that it is okay, permissible under DPSP, it is possible, it is not violating basic structure, but in the dissenting point of view, they said it is violating not because of the amendment, not because of the article, not because of this overall structure, it is because it is having some exclusive principles, and that's the reason it is violation of basic structure. It violates basic structure because it is excluding the people, and they have empirical evidence also, practical data also to say that economic weaker section doesn't exist only in the economic weaker section, doesn't exist only in the general category, even in the weaker section. So we need to use this reservations for them also. So there is a ceiling limit also 50%, which is also cautioned by, because this kind of things will definitely violate it. So we need to follow the care or caution on this principle. And finally, here two important judges observation. One is Justice Trivedi and Justice Pardiwala both mentioned that there should be a time span for reservation. There should be a time span for reservation, because reservations itself, if you keep on continuous it will create again inequalities among the people. So there should be a time span for the reservation that should be done. Okay, and just here Justice Pardiwala clearly mentioned the reservations not an end but a means to provide socio-economic justice to the people. So this should be put forward, this should be followed very clearly, and there should not be any vested interest on this. Okay, the main intention is the reservations should end the factors which is causing socio-economic discriminations. So one has to do that with this reservations itself. That is the idea of, that is the point of Justice Pardiwala. Finally, Justice Ravindra Bhatt, who opposed this, who raised his voice against this, he quoted B.R. Ambedkar observation on the reservations. Even I would like to quote the same, because he said that the reservations are to be seen as temporary and exceptional. Okay, the reservations are to be seen as temporary and exceptional, and if this continues, it could eat up the role of equality. B.R. Ambedkar said this quotation. I will quote again. The reservations are to be seen as temporary and exceptional. If this continues, they could eat up the role of equality, unquote. And this is important discussion about economic weaker section judgment which was came yesterday.